Welcome to the third video on the enforcement and validity of international arbitral awards. In this video, we will answer one fundamental question. How can a successful party enforce an arbitral award and obtain the compensation awarded to it? In the previous video, we saw that a party can challenge an award based on certain limited grounds. In this video, we will see how a party can enforce an arbitral award and which procedures can be used to that effect. In most cases, the unsuccessful party will voluntarily pay its due to the other party. However, it may occur that the unsuccessful party refuses to comply with the award, and as a result, enforcement proceedings will be necessary. The procedure to enforce an award varies, and it depends on the legal system where you seek enforcement, as well as on the arbitration rules that were used during the proceedings. In practice, enforcement will be sought in a state in which the party against whom you seek enforcement has sufficient assets. Often, domestic legal systems will require recognition as a preliminary step before enforcement proceedings. It is important to emphasize that recognition is different from enforcement. Recognition results in the award having the same status and effect as a court judgment. Recognition of the award requires acknowledgement of the award as valid and binding. This gives an effect similar to a court judgment. Thus, the award has an official status, and issues that have been determined by the award cannot be re-arbitrated. On the other hand, enforcement of the award is the process to collect the amount owed or to otherwise carry out any obligation provided for in the award. For non-ICSID international arbitral awards, a convention was signed in 1958. The Convention on the Recognition and Enforcement of Foreign Arbitral Awards, in short, the New York Convention. Many states are parties to the convention. The New York Convention imposes an obligation for national courts of one contracting state to recognize and enforce foreign arbitral awards made in other contracting states. The New York Convention's main objective is to ensure a form of uniformity in the recognition and enforcement of foreign arbitral awards. The Convention applies to non-ICSID investment treaty arbitration, as well as to international commercial arbitration involving a state or between two private parties. The party who seeks recognition and enforcement under the Convention is required to provide the original award or a certified copy thereof, as well as the original arbitration agreement. Article 5 of the Convention lists the grounds on which courts and tribunals of states can refuse recognition and/or enforcement. These grounds are exhaustive. It means that only those grounds on which recognition and enforcement can be refused. The grounds are, first, invalidity of the arbitration agreement, secondly, no proper notice of the appointment of the arbitrator or of the proceedings, third, excess of authority by the tribunal, fourth, constitution of the tribunal not in accordance with the agreement of the parties, fifth, the award is not yet binding or has been set aside, 6. The dispute was inarbitrable under the laws of the state where recognition or enforcement is sought. And finally, recognition or enforcement is contrary to the public policy of the state where recognition enforcement is sought. The domestic courts of the state where such proceedings are taking place therefore retain much authority to refuse a request to that effect. The specific court or tribunal competent to decide such proceedings will depend on the domestic law of the state where enforcement is sought. The situation is very different in the case of ICSID arbitrations. Article 53 of the Convention provides that each contracting state shall recognize an ICSID award as binding and enforce the pecuniary obligations imposed by that award as if it were a final judgment of a court in that state. This means that contrary to the New York Convention, domestic courts of the state where recognition and/or enforcement is sought cannot refuse such a request. This is one of the main advantages of ICSID arbitration. The counterside of this, however, is that ICSID has its own procedure to deal with claims to annul arbitral awards on grounds that are similar yet not identical to the New York Convention, as we have seen and discussed in the previous video. A final word on awards rendered in disputes between two states, such as under the Law of the Sea Convention, which we have discussed in the second module. Such awards need not be recognized, nor can enforcement be obtained through the domestic courts of other states. Indeed, as we will see in the next video, states have immunity from jurisdiction. This means that it is impossible to sue a state before any domestic courts other than its own. Enforcement of interstate awards is regulated only by general principles of public international law. However, states usually voluntarily comply with international arbitral awards. In this video, you learned how awards can be executed, and on which grounds recognition and/or enforcement can be refused. You also learned an important difference between ICSID and non-ICSID arbitrations. One last fundamental issue, however, must be addressed. Enforcement proceedings and annulment or set-aside proceedings can be conducted in parallel. We will discuss this situation in more detail in a future video when we will look at the UCOS case.